Paullette Altmaier. Paullette and her husband, Rich, this is our next topic, are the force and most of the funding behind the Tandon versus Newsom lawsuit aimed at ending these seamless, endless lockdowns. It's just, this is getting crazy. Anyway, she's returning to SVARW today to fill us in on the status of it and what's going on. Please welcome Paullette.
Thank you, Wendy. And thank you all for this opportunity to speak about this. So the issue here is that we really need to fight what I can only call COVID totalitarianism on multiple fronts. At the ballot box, of course, with the recall, but we also have to fight it in the courts, because otherwise this is going to happen again. What's basically been laid out with what's gone on so far is a template for us to lose the Bill of Rights, because we are being told that under health emergency powers, the government can literally lock us in our homes and ride roughshod over all our rights. So that's why we brought this federal lawsuit, Tandon versus Newsom. And the emphasis in it is the loss of individual rights and the right to earn a living. There are many church lawsuits, so we did not focus on that. We focused on these other areas, the individual rights and right to earn a living. The main defendant is the state, namely Newsom and his health officers. But because of the extraordinary powers that county health officers have, we also added the county, an example, I should say, county. And since most of the plaintiffs were in Santa Clara County, we have added Sarah Cody and the Santa Clara Board of Supervisors. But that was really meant to be the stand-in for all counties, because county health officers have these extraordinary powers and can do whatever they like, and they have, in many cases, have done worse than Newsom by way of restricting liberties. So the lawsuit has three sets of claims. One relates to the right to earn a living, and the plaintiffs are small businesses, and there the claims relate to the 14th Amendment equal protection and Fifth Amendment due process. Then the other two sets of claims are a First Amendment free speech, and that's political speech. As you know, right at the beginning, people weren't even allowed to protest what was going on. And later, when BLM came along, people were allowed to protest, but it was still very restricted. So we have political speech claims, and we also have First Amendment free exercise claims, which are not church related, but related to private individuals being able to get together. As you know, right now, nobody's allowed to get together at all. And one thing that we really emphasize in the lawsuit is we've heard a lot about deference and the SCOTUS South Bay, that disastrous May decision, which had such a chilling effect from John Roberts, talked a lot about deferring in this health emergency to the so-called expertise of our health officers and the governors. And to combat that, we've drawn a very strong parallel to what happened with the Japanese internment, the so-called the Korematsu case, because many people think that was a racial discrimination case, but it was not. If you read the Supreme Court decision, that was all about SCOTUS deference to the military emergency and saying we cannot second guess the military when there's a very genuine military emergency. So in that case, as we all know, they ran absolutely roughshod over individual rights, and we are pointing out that they are doing exactly the same thing here. So we also have two expert declarations. And the key points are that you've heard the state and the county constantly parrot this absolutely false claim that they are following the science and the data. They absolutely are not. And so the expert declarations point out that medical science is not being followed. And as far as public health is concerned, both public health ethics and public health best practice are being massively violated by the California blueprint. We did get a very small win right when we filed. The state knew that its limitations on political speech would never make it, and so they immediately amended the definition of protests to include all political gatherings at that time. Can we move to the next slide, Wendy? Yeah, okay. So with that background, I'll move on to the status, which is very brief. Our hearing was December, actually it was 17th, not December 10th, in federal district court. There is no ruling yet. In terms of the overall environment, the positives are, as we all know, the SCOTUS Diocese of Brooklyn ruling overruled that terrible South Bay decision from May. And there have been favorable circuit court rulings then in other circuits, but notably not in the Ninth Circuit. And in the last 4 days, and that brings me straight to the negatives, there's no relief yet in California from that Brooklyn ruling. And on Friday and Monday, the Ninth Circuit ruled on 2 cases, Harvest Rock and South Bay, and some of their reasoning literally directly contradicted the SCOTUS reasoning in Brooklyn. So both those cases have now filed with the Supreme Court, and really SCOTUS is our only recourse. The good thing to know is that the Ninth Circuit is the most overruled circuit in the entire country, because they are constantly coming out with rulings that ignore Supreme Court precedent. But the bad thing is, of course, it delays relief in California. But that's the status right now. So this is really important, as I said before. These lawsuits that are coming through, so far they've been mainly church lawsuits, but we really need, as I said, to focus on the other liberties that have been literally eradicated. But these lawsuits are extremely expensive. But our liberty depends on fighting it and winning. Although the Center for American Liberty, which is Harmeet Dillon's organization, her nonprofit, they are not able to fund this lawsuit, but they are giving us some in-kind help. They've set up a tax-deductible, fund, as it were, where if you donate towards this public interest lawsuit, your donation is tax-deductible, so that to help. So, I would like to ask for people's help. It's been extremely expensive, several $100,000 already. So, your support would be much appreciated. As I said, we are committed to continuing to fight this battle, because really we feel that our liberty in the future depends on it, because this template for template for tyranny will be used again if we don't fight it. Thanks, Wendy. And thanks again for your time.
Thank you, Paullette.